Dear Dean, esteemed professors, honored speakers, dear participants and students, welcome to the conference on Private International Law and Sustainable Development organized by the Bilkent University Faculty of Law. It's a privilege to open this conference, which brings together leading scholars to examine how private international law engages with sustainability challenges, from global commerce to personal status and climate-related disputes. Before we begin, I would also like to note that this conference is being live-streamed on the official YouTube channel of Bilkent University Faculty of Law. To begin our program, it's my great honor to invite the Dean of the Bilkent University Faculty of Law, Professor Dr. Başak Baysal, to deliver the opening remarks.
I'm not so tall. Welcome everyone, dear colleagues, dear participants, dear students, and everyone joining us online. Ladies and gentlemen, as the Dean of the Faculty, I'm truly honored and delighted to welcome you all to the Private International Law and Sustainable Development Conference. It's a great privilege to bring together such a distinguished group of scholars. Allow me to briefly, but very briefly, share a few thoughts on this highly important topic, especially climate crisis and private law, since climate crisis is one of the key aspects of sustainability. As is often said, we are the first generation, you are the first generation, I'm half the first generation, to feel the impacts of climate change so directly, and probably the last generation that can do something about it. We have already experienced many serious consequences of climate change worldwide. Then, what can private law do about climate change? This question is often asked as to what extent can tort law be part of the solution to the climate crisis? As a tort lawyer, I have the tendency to bring the topic to the tort law even. It's sustainability conference. Many scholars are quite pessimistic about this and think that the simplicity of tort law is not enough to deal with the complexity of climate change. Tort liability mainly focuses on harm caused by one person to another. Nevertheless, tort law is often at the center of climate litigation, but its role is still limited. In legal doctrine, the situation is sometimes described as the anti-tort structure of climate change. How can risk be shared in a situation where everyone in the world contributes to the harm? The complexity and in particular cross-border nature of climate litigation pose a real challenge for private law. Tort law is also still largely tied to national borders, and even the harmonization of tort law remains very difficult. So how can it be a solution to a transnational problem like climate change and sustainability? Waiting for the harmonization of tort law rules for these time-sensitive problems may not be the best solution. It may simply take too long for problems that are already urgent. This is where private international law becomes essential. It gives us the tools to think beyond borders and hopefully start finding more immediate and practical solutions. Without private international law, the limits of national private law will make it difficult to address transborder problems such as climate change, supply chain liability, and migration-related legal issues. National private law was challenged by sustainability as a transborder problem. As Professor Michaels points out in his article co-authored with Samuel Ze, titled Sustainability and Private International Law, I'm just quoting, "Private law can only make a significant contribution towards sustainability if it has transborder effectivity, and its full operation can only be understood by accounting for its transborder dimension. This transborder dimension is the domain of private international law, and an analysis of private law that does not take private international law into account is likely incomplete." This is certainly true. In this context, private international tools can offer more immediate, flexible, and effective solutions for sustainability and sustainable development. Our distinguished speakers have come to Bilkent to discuss legal challenges related to sustainability and private international law. The program was prepared taking into account the Sustainable Development Goals, which are an urgent call for action by all countries in a global partnership. One of the factors that makes today's conference important for us is that the issue of private international law and sustainable development is being addressed for the first time in Turkey. And also, we are particularly delighted to have the three editors, Ralf Michaels, Veronica Ruiz Abunir, and Hans von Loon, and one of the authors, Gülüm Özçelik, of an important book as speakers of this conference, The Private Side of Transforming Our World, UN Sustainable Development Goals 2030, and the role of private international law, which is the most comprehensive publication on this subject to date. That is why, as a tort, I think everybody understood I'm a tort lawyer, and a comparative lawyer, I look forward to hearing the presentation and discussion at this conference. I would like to thank all faculty members who contributed to organizing this conference and helped make this event possible. I would especially like to express my sincere gratitude to my dear colleague, Professor Gülüm Özçelik. Without her efforts, we would not have been able to bring together such a distinguished professors of private international law. I would also like to thank our administrative office members, Burcu Bingöl, Senem Şen, Seçil Yemenici, and Sude Özcan, for providing all the assistance needed to organize this program and for their outstanding efforts in making this conference possible. My sincere thanks also go to our researchers, Elif Gökçen Toksoy and Hafsa Nida Köseoğlu. And again, I would also like to extend my thanks to our technical team. Our live streaming is expertly handled by Emre Müderrisoğlu, ensuring that our conference reached audiences beyond this room. I would also like to thank Ercan Korkmaz and his team for managing all the other technical aspects. Their hard work behind the scenes has been essential to making this event possible. Finally, I would like to express my deepest appreciation to our speakers for dedicating their valuable time and expertise to this conference. Before I leave the floor to Professor Tiryakioğlu, our moderator for the conference, I want to say once more, on behalf of the Bilkent University Faculty of Law, welcome. It's a pleasure to see so many of you here. I'm also sure that this conference will create a fruitful network which leads us to the new collaborations. I wish you all a productive conference. Thank you.
We would like to thank our Dean, Professor Dr. Başak Baysal, for her valuable speech. Today, we are honored to host a panel of distinguished experts who will discuss the evolving role of private international law in the context of sustainable development goals. At this point, I would like to invite our moderator, Professor Dr. Bilgin Tiryakioğlu, a faculty member in private international law at Bilkent University, together with our distinguished speakers, Professor Dr. Ralf Michaels, Director of the Max Planck Institute for Comparative and International Private Law, Hamburg, Professor Dr. Veronica Ruiz Abunim, Professor of Private International Law at the University of Edinburgh and member of the Permanent Court of Arbitration, Professor Hans van Loon, former Secretary General of the Hague Conference on Private International Law and honorary professor at the University of Edinburgh, and Associate Professor Dr. Gülüm Özçelik, faculty member in Private International Law at Bilkent University Faculty of Law. We would be honored by your presence at the lectern. Thank you very much.
Distinguished Dean, esteemed colleagues, and dear students. It's my great pleasure to welcome you to this conference on private international law and sustainable development. At the outset of our panel, I would like to express my heartfelt thanks to my colleague, Associate Professor Gülüm Özçelik, who first proposed the idea of this conference and played a key role in its organization, and to our Dean, Professor Başak Baysal, whose encouragement and support were instrumental in making this panel possible. As global challenges become more interconnected, the role of private international law in addressing such issues, climate change, sustainability, and human rights, is more crucial than ever. We are fortunate to have four panelists, excellent panelists, with us today. Our panelists' academic achievements are both remarkable and inspiring, and they could certainly justify a much longer introduction. However, in the interest of time, I will keep this introduction brief. Each panelist will have approximately 20 minutes for their presentation. After all presentations, we will open the floor for the discussions and Q&A questions from audience. Without further ado, let us begin with our first panelist. It's my great pleasure to introduce Professor Ralph Michaels. He is director at the Max Planck Institute for Comparative and International Private Law in Hamburg, and holds a chair in global law at Queen Mary University of London. He's also served as professor of law at the University of Hamburg and previously held a long-term position at Duke University School of Law. His research focuses on private international law, comparative law, and global legal theory, and he is widely recognized as one of the leading scholars in the field. Today, he will speak on the place of private international law in sustainable development. Professor Michaels, floor is yours.
Invitation. Thank you, Dean Baysal, for the friendly introduction. Thank you, everybody, for coming to this. It's a great honor. It's a great pleasure. It's a pleasure to meet here again with the co-editors of the book that was mentioned before, but it's also a great pleasure to be here in Turkey, in Ankara in particular. It's my first time here, and it's very heartwarming to see the great interest in the topics that we think are important. I will introduce the topic, so the interesting presentations will be the ones coming after mine, but you may not understand them if you don't listen to mine, so that's what you have to go through. And I hope I don't speak too fast. I have 20 minutes. I will hope to do my best with that. My task to talk about is the place of private international law in sustainable development. And so I want to speak very briefly about what we mean by sustainability and sustainable development. I will speak about how this is a challenge to private law and private international law. I will speak then as the functional relationship between sustainability and private international law. And I'll briefly mention two examples, one being climate litigation and one being supply chains liability. Let me start then with my first topic, sustainability and sustainable development. Time's up already?
Yes.
I'm almost finished. What do we mean by sustainability, sustainable development? Remarkably, we still base that on a UN report, the Brundtland report from 1987, that means almost 40 years ago, that defines sustainable development as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. So this comes from development policies at the United Nations and adds the question of sustainability because it is feared that unlimited growth might be unsustainable. And so we can see here the needs of the present are mentioned, but also the needs of future generations. And you can see already that there's a tension in there. There's a tension between the growth on the one hand that is liberating and the idea of limitations that is limiting. Or, put differently, between growth on the one hand and limits to growth on the other. What do we mean by sustainability? We often say we want to combine three fields, one being the economic, one being the social, and one being the environment. And think of sustainability only where all three come together. That means, for example, that realistically, we think sustainable development needs to contain all of those. We cannot have either development or sustainability. We also think the sustainability includes both the social and the environment. So there also we think we need to transcend these tensions, but of course the tensions are there. And one famous, important formulation, of course, of these principles of sustainable development come in the Agenda 2030, the 17 Sustainable Development Goals, which are really broadly formulated policies on the UN level, and perhaps because they have such nice colors, have been very influential in global debate. Now, how does sustainability come as a challenge to the law and to private law in particular, and private international law? We have a tension between sustainability and capitalism. Why? Because capitalism rests on creative destruction, on destroying the old to make place for the new. And sustainability says that is exactly what is not sustainable. There's also a tension between sustainability and development, as I mentioned, development being about growth and sustainability being about continuity. And one approach to do that would be to say we allocate the responsibility in different fields of the law. So private law takes care of capitalism and development, contracts, property, corporations. Public law takes care of protecting the planet and everything else, sustainability. And private international law is this merely technical discipline that allocates jurisdiction, applicable law, without having any policy decisions in itself. I assume everybody in the room knows what private international law is. What we do really is, we have three areas in the field. One is the jurisdiction of courts, one is the applicable law, and one is the recognition and enforcement of foreign judgments. So take an example, an oil spill in Nigeria created by or by the responsibility of a Dutch company. The first question is jurisdiction. That means, can you sue in Nigeria? Can you sue in the Netherlands? Or can you sue perhaps in New York? The second question is which law applies. Is it Nigerian law? Or is it Dutch law? Or is it perhaps some other law? And the third question is recognition and enforcement of judgments. So if you have a judgment from a Nigerian court against a Dutch company, can you take that to the Netherlands and enforce it against a Dutch corporation? Those are the three areas that we deal with in private international law: jurisdiction, applicable law, and recognition and enforcement of judgments. If you don't know anything about the discipline, you see immediately how politically relevant this is. Because if you can't enforce your judgment, the judgment isn't worth much. If you can't bring suit at a court that is favorable to your case, you don't have a case. But in the discipline, for a long time, we thought really this is merely technical, it is neutral, it does not care about the policies itself, and that is one reason why private international law and sustainable development or sustainability have, for such a long time, not been thought to have anything to do with each other. You can see here I distinguish these three fields according to three classical functions, if you want: facilitation in private law, facilitate trade and exchange; regulation in public law, regulate, limit; and coordinate in private international law, coordinate between different legal systems. Private law is certainly central to the causes for unsustainability. And so we would also think that private law also has a role to play in remedying those. We traditionally think it does not. We think that private law is about growth, is about freedom, and is not really about externalities. What do I mean by that? It is about growth in the sense that property rights, contracts, corporate law enable people to create value, to grow, and thereby feed the growth of economies altogether. We think a basis of that is freedom, individual freedom, property rights as freedom rights, contract as freedom of contract. And we assume, to some extent, counterfactually, that there are no externalities. So contracts are binding only between the parties. And they cannot make anyone else worse off. And so we think of contracts as win-win situations. We think of property rights as excellent because property owners internalize their costs. If you destroy your own property, you yourself have to bear the costs from that. But we also know that none of this is really true because, of course, contracts that create a win on both sides in a limited world have to create losses elsewhere. So they're really win-win-lose. And the loss is somewhere outside, either in society or in the environment. We know that property rights enable property owners to destroy beyond what they own, beyond what they're responsible for. So we know that private law has some of these problems. I also think that private law has a lot of potential. And so one chance in private law would be not only to limit it through public law. We have public law rules that say here are the contracts you cannot have, here are the property rights you cannot have, but instead reorganize private law in some way to come from freedom to responsibility, from growth and destruction to sustenance, and from the fiction of no externalities to the reality perhaps of a circular economy. And we would then have property rights as stewardship rights, contract law as circular law, and tort law not as damages law but as regeneration law. I'll just mention this here briefly to suggest there is something in private law that then also plays a role in private international law. Because, of course, the real issue of our research is in private international law. But at the same time, and Dean Weiss already quoted that, private international law in many ways is the extension of private law. And so we cannot properly look at private international law without having a sense of what's there in private law. Having laid that down now, I come to private international law to suggest that the functions that I just identified before and allocated among public law, private law, and private international law really all appear also in private international law. So I want to suggest first they all appear in private law. Private law facilitates in contracts status property. It facilitates contractual freedom. It facilitates individual action through property rights. Within my own property, I can decide what I want to do. And through status, through the recognition of who I am, it facilitates my activities as a woman, as a married person, as a Muslim, and etc. So all of these are facilitating. They're liberating in that sense. They're at the same time also regulations in private law, partly because we have requirements for marriages, requirements for the establishment of a corporation, etc. And in part, of course, direct limitations of freedom of contract, of freedom of use of property, etc. And there's also coordination in private law. A lot of what private law does, this is the ordoliberal theory, it coordinates markets, makes sure that markets function properly. So it not only protects individual freedom, it also organizes how the freedoms of different individuals interact in a way that is conducive. Now, how does private international law extend this? Really in two ways. The first is it just expands all of these things across borders. And that's underestimated by people who don't look at private international law. And it is really wrongly underestimated because in a system in which you have rights only under Turkish law and nowhere else, and in a system in which you can take your Turkish law rights everywhere in the world, you can clearly see that private international law is much more important than private law. Because private law protects you only within the very limited realm of your own legal system, and private international law really universalizes the rights and status and privileges that you have. So it extends the facilitation because it means that your contractual freedom creates contracts that exist elsewhere too, that are binding elsewhere too. It extends your status. Your status is recognized across borders. Your property rights are extended across borders. It has a regulatory function in that sense because it extends regulations across borders. And it has a coordination function because it coordinates global markets as opposed to just domestic markets. So that's the first way in which private international law has a regulatory, a facilitative, and a coordinate function. And then there's a second way, and that is perhaps more the classical way, and that is the relations between legal orders. If you start from the last one here, coordination, of legal orders has always been looked at as the core function, the prime function of private international law. And the prime goal has been decisional harmony, the idea that a case would be decided the same way everywhere. So my case about spillage of oil in Nigeria would be decided the same in a Nigerian court as it would be in a British court or in a New York court. And so in that sense, there is one kind of coordination between legal systems. There's another that is regulatory competition, but I won't get into that at the moment. Private international law has the other two functions as well in the second way. Private international law facilitates in the sense that we have party autonomy. We allow parties to choose the competent courts and the applicable law. We put, in that sense, parties above state laws. It's no longer the state law that defines your freedom of contract. It is your freedom of contract that decides which law applies in the first place. And private international law has a regulatory function because through the choosing of connecting factors, it sets incentives and it creates limitations on conduct. So all of those three functions are performed in private international law as well. Let me go through those again one by one and link them to some examples in the Sustainable Development Goals. I copy some up there in part because the colors are nice. I would not say that the Sustainable Development Goals, the 17 of them, are all directly responsible for one or the other of the functions. In fact, one of the attractive things about them is that they try to combine all those functions. They're both facilitative and regulatory and coordinate. But maybe some are more on one side and one are more on the other. SDG 16, peace, justice, and strong institutions, and SDG 17, partnership for the goals, are certainly most in the coordination function. As I said, coordination happens individually. Coordination happens for global markets. And coordination of legal orders also happens through decisional harmony. Let me just take one example, simple example, Article 4.1a of the Rome I regulation. A contract for the sale of goods shall be governed by the law of the country where the seller has his habitual residence. Assuming that the habitual residence can be assessed objectively, that is, everyone agrees on that, and that's a big assumption. This means if this is the rule in Europe, every member state in the European Union will apply the same law to a contract. And that means no matter where you sue on the contract, the result will always be the same. And we have coordination of legal orders in the sense of decisional harmony. So that's clearly one goal and one function of private international law. But the second function, as I said, is a facilitative function that exists here as well. So private international law itself has a role to play in growth and development. Two SDGs I mentioned for that is number 1, no poverty, number 8, decent work and economic growth. As I said before, in private law, we do that through recognition of status, property, and enforcement of agreements. In private international law, we do it through cross-border recognition of the same. But we also do it through private international law. As to this first, take another example here. This is Article 13.1 from the German Private International Law Code. This is essentially meaning if you got married at home, your marriage will be recognized everywhere in the world. I wish this were a recognition rule. It is not, so I'm faking a little here. But 2 Syrians who get married in Syria will be considered married everywhere in the world. So there's a cross-border recognition of status there. That's the first here. This is this first facilitating function. And the second, as I said, is party autonomy. Parties can choose the jurisdiction. If the parties have agreed that a court of the courts of a member states are to have jurisdiction, that court or those courts shall have jurisdiction. And it is about applicable law. A contract shall be governed by the law chosen by the parties. So the parties can choose these things, and so there's a lot of facilitation in there. And this, we're pretty sure, has been responsible for a lot of growth and development. In part, the possibility for investors to avoid regulatory laws from the states in which they invest has led to development and growth. It has also led to exploitation and destruction of nature, because obviously managing to avoid regulatory rules of the state in which you invest can also mean avoiding the environmental protection, etc. So the third function, how is that performed then in private international law? The regulatory function. Again, it's a function that exists in substantive private law, restrictions on property, and the challenging of incentive tort law having an incentive function and thereby a regulatory function, because corporations who have to fear tort liability will adapt their conduct to that. Private international law internationalizes those, makes those available across borders, and that's quite important. That is, the incentives of tort law are carried across borders, and obviously certain rules are made internationally mandatory. One example from the Rome I regulation again is about overriding mandatory provisions. So rules that bind regardless of which law applies otherwise, and also regardless which law the parties have chosen to apply. But also in the German law that I just mentioned about the recognition of foreign marriages, there is a rule that says if the parties were married before one of them was 16, then Syrian law will no longer apply and German law will apply. I find that a very problematic rule. We have a huge study in Hamburg on why that is a problematic rule, but it serves as an example here of the regulatory function, the private international law rule that says Syrian law will no longer apply if you got married too early. And then second, private international law rules also regulate and set incentives. Think of a place of conduct rule versus a place of injury rule. You can think easily a country that relies on a lot of polluters, that makes its money from pollution, will have very low liability standards because it profits from pollution and the pollution crosses the border. A state that is a recipient of that will have very high regulatory standards. So whether the law of the place of the conduct or the place of the injury is applicable has an impact on the standard of liability and on the regulation. The same is true in corporate law, whether you use the place of registration, that is Delaware law, which has very low requirements, or the place of effective business, which may be another one. And a third example is in contract law, indeed. Do you use the buyer's law or the seller's law? There's an argument from Africa to say we're an exporting continent, we should use the seller's law much more often because then we get the protection from African laws. So much as the basis. I'm through with my time, but I will just use 1 minute each for the 2 examples that I have, if I may.
Okay.
Should I not?
I'm excited to.
Good. I'll be very brief. One is climate litigation. Obviously, that was mentioned already. That is also one of the SDGs. And that creates problems on all 3 of these bases, as I just said. Should jurisdiction lie in a country, in a court in the global north? So you have access to an efficient system, the Nigeria example. Should it in fact be in the global south, as Vero Ruiz has argued recently, in order to strengthen institutions there? Should you be able to go to Nigerian courts, in my example? Applicable law obviously makes a difference. As I said, place of conduct or place of injury, or indeed having the choice under the Rome II regulation, you can choose between the place of conduct and the place of injury. And thirdly, if we think further, we'd have to think about whether the standards, the requirements in climate law would not only be domestic laws, because any choice of law rule depends on the substantive laws being there, but on some global standards. And another area on which a lot of research is done at the moment is emission certificates in their trade, and this is actually also a private international law issue. The second example for me is supply chain liability that I won't really get into because of the complexities, except maybe to mention one aspect, and this: the European Union, of course, had for a long time the plan of a corporate sustainable, what's it called, triple D? Sustainability due diligence directive that would require corporations that do business in the EU to comply with certain sustainability standards and make the respective rule mandatory internationally. So even foreign corporations and conduct elsewhere would be governed by EU law. And private international lawyers were mixed about that. On the one hand, they said it's good that there's a standard that is made and that is held against these. On the other hand, it's deeply problematic because it crowds out the local standards that may in fact be better and maybe more appropriate. Just one example, we have a lot of employee protection in this from a European perspective. We have a lot of African markets where we don't have contractual employment relations. So employees are not employees, they're independent workers, and so the European standards don't fit very well. And we think that private international law actually is more case-specific than this kind of very dramatic public regulation. But over time, I apologize for that. I gave you the project website, and I thank you for your attention.
For your very engaging and very inspiring presentation. Actually, I love the private international law's function about coordination between legal systems. And I also believe in cooperation with all kind of relationships in our world. So it was really inspiring for me, and I think for our audience. Thank you so much. Now, I give the floor to our second panelist. It's my great pleasure to introduce Professor Veronica Ruiz Abu Nim. Am I pronouncing your name correctly?
Yes.
Okay. She is chair of private international law at the School of Law of the University of Edinburgh. Veronica has experience in private international law in the UK, Europe, and Latin America. Her work has been published in English, Spanish, and Portuguese. Veronica is president of the American Association of Private International Law, former president of European Law Faculties Association, member of the court of the PCA, Permanent Court of Arbitration, and member of the Scientific Council of the European Association of Private International Law. Today she will present on sustainable consumption and production.
Thank you very much. Thank you very much for the kind introduction. Thank you very much to Dean Bashek and Gulum for the kind invitation. We are delighted to be here. Thank you very much to all of you for allowing us to share our research with you. It's really a pleasure and very much an honor to be at Bilkent University in Ankara. So, as I was told, I'm going to talk to you particularly about one SDG, that is SDG 12 on consumption and production. And actually the SDG is about responsible consumption and production. And I'd like to talk to you about these two sides of SDG 12. But I'll do that specifically in relation to one sector, which is the fashion industry, which is at the moment presenting and we can call an unsustainability crisis. So enormous problems at all levels of sustainability, not only environmental sustainability, but also social sustainability and economic sustainability. So in that sense, very much bringing the three dimensions that Ralph was talking to you about. So building on that, one possible solution that is getting traction is the circular economy, and I'll talk to you about what are the basic principles of the circular economy and how law is engaging with that, how law is actually starting to produce regulatory framework to that extent. At the moment, private international law is not necessarily very much engaged with that, and we want to actually show why private international law matters, why it matters in that transition to circularity. And I'll finish off with telling you that this is all about a project that we are just started in February this year, together with Antonia Sommerfeld from the Max Planck in Hamburg and Ralph Michaels and Michael Picard from the University of Edinburgh. So this is just, the beginning of a project, and therefore I love to have the opportunity to share this with you. So let's start with the problem, right? The fashion industry sustainability crisis. In the rich data about how much water it takes to produce a pair of jeans, and then how many years a person bathing will have to go through for that same amount of water. So in that sense, the reality is that environmentally, sustainability is really problematic for the fashion industry. But as I said before, it's not only environmental, the social aspect of it is really crucial as well. There's a lot of work in the fashion industry that is not dignified work, and there's a lot of problems in terms of the informality at the bottom of the supply chain. A lot of that is not very visible, so there's issues of transparency when it comes to this industry, and part of the regulatory frameworks are actually engaging in trying to make that visibility more there, and we'll say why it's so important to have that information reporting. So in terms of the what Ralph was talking about, capitalism, in terms of the linear economy, that is the model that we use, kind of, the unsustainability comes very much from the way we use clothing, very much from a point of production that is based on extraction and production and end up in waste. So at the end of that linear model, you have waste. And this actually presents problems at all points in the production and consumption. When it comes to production, as you know, it's well known, there's pollution. Many of that pollution happens in places that have very or low environmental protection, and therefore, you know, the picture that you have there is for Bangladesh, which is an economy that is very much based on the fashion industry and the pollution of rivers there. But you have the same kind of problem at the end of the life cycle, and textile disposal is something that generates problems across the world. The pictures you have here are of Ghana and Chile in South America, but recently other pictures and aerial takes from places, for instance, in the north of Argentina, are showing how much is affecting particularly the global south, or many places in the global south. And actually, in terms of data, again, it's been known that out of 5 garments that are produced within 1 year, 3 of them will end up in a landfill within that year. So the level of waste is alarming. It really is. So the other factor here is the globality of the journey of textiles, as I said before, is very uneven. In that sense, you have production, a lot of that concentrated in central countries, particularly Southeast Asia. Places where consumption is the highest tend to be in developed countries like Europe, the US, Japan, and places of disposal tend to be, again, in the global south. So you have a very global supply chains, very complex supply chains, but in terms of the distribution of risks and liabilities, and actually who is going to be bearing the negative externalities of all this change, very much tends to end up in a very uneven way in the global south. Production and consumption in all sectors. This case study is fashion, but this applies across the board. But there are other initiatives. The UNEP Textile Initiative 2023 is one of them. All of this being, as you well know, in a way, soft law, policy agendas, not necessarily binding instruments that will actually be in any way filtered down to the level of binding law. At the regional level, with a little bit more dent, you can say, the European Union is front-running, and after the European Green Deal was adopted in 2019, there's a range of measures there. And at the national level, there are, and this is data from a World Economic Forum report that was published last week, there are 49 countries that have adopted circular economy plans. So in that sense, the level of engagement at the national level is also gaining traction in that sense. So it's key for the Sustainable Development Goals that actually sustainable fashion moves to a more sustainable model. And in that sense, it engages very much with the two sides of SDG 12. So we go to SDG 12, and I find it particularly important that the Agenda 2030 pairs consumption and production. So when we're talking about many of these problems from a business and human rights perspectives, for instance, we tend to focus on the production problems. A lot of these things have actually been studied, and we have cases related to the production of clothes in the global south that very much focus on the problematic issues of production. And you know, we do have to tackle that, but it's really important that we also reflect, and that gets to all of us more personally, what can we do from the consumption side of things? And how it is that we are feeding, and we are also responsible, and that's the name of the SDG itself, in terms of the way we consume garments. In this case, particularly, we consume clothing. So when we looked at the SDG 12 from private international law, and in the book that Ralph was mentioning, it was Geneviève Sommier, a colleague from Canada that actually worked on that chapter, we very much identified different things that private international law could do on both sides, on the production side and on the consumption side. And it was that, very much first look at the SDG 12 from private international law that allows us to move forward with it in particular work that we are doing with Antonia Sommerfeld, and I'll tell you a little bit more about this in a minute. So, what is the circular economy, and why we decide to focus on circularity as a possible solution? First of all, because the fashion industry is one of the industries that has more potential when it comes to the transition to circularity. So many industries have been identified and are engaging with it, but the level of engagement of stakeholders, companies that are moving to circular models in fashion is very, very interesting. Having the stakeholders on board makes the whole difference in terms of all sorts of processes that are involved in transition into circular economy. So the circular economy has been defined as an industrial system that is restorative or regenerative by intention and design. And it has been explained as a multi-R project: rethink, redesign, restructure, repair, redistribute, reduce, reuse, recycle, recover energy. So it's all about that R. So remember, that R thing is what we need to think about every time we engage in the way we not only buy, but use and then recycle and go into the other side at the end of the using of the garments. And it is very important that we remember that circularity has two particular aims. One of them is to keep the garment for longer. In that sense, it's called try to keep the garments in the loop for a longer period of time, and actually, maximize the life cycle of it. But also at the end of that life cycle, make it, back into the loop, right? So these two aims are crucial, and it translates in the two sides of circularity. Repairing models and reuse models are part of slowing down the cycle, but then when we want to close the loop, we talk about upcycling, recycling, and all the logistics to make that happen. I told you already that the fashion is particularly an industry that can be harnessed in terms of circularity, and this can happen at every stage of the production and the consumption. So for that slowing down the loop, one thing that is really important is to make the production in a way more durable. So the durability of garments is also based on the source of kind of materials that are used, but also on the processes of identifying the materials that are used to enable the recycling at the end of the life cycle. And this sort of potential for circularity extends to these three stages of production and consumption. So this is why we're focusing on this, but what we know is at the moment, globally, law is very much lagging, right? We have, as I said, 49 countries that have engaged with action plans, but not necessarily with legal frameworks to enable that transition. And the one that is clear in not only in the intention but in establishing these frameworks is the EU. You have several directives there. Many of them are going to start being applicable this year. So the ones that were adopted in 2024 become applicable from July, August, September this year. So many of these try not only to tackle the production side, but also very much the consumption side, and making the consumer an agent and providing the necessary information for the consumer to actually take informed decisions when it comes to, to consumption is really part of the plan, as it should be. But private international law is, in that sense, not necessarily something that is reflected upon. There's really no research in relation to circular economy and private international law. In that sense, not only the private international law, the private side of transforming the world was the first project of its kind. This one on circular economy and private international law is also the first one of its kind. And I wanted to show you, this is the map that appeared in that World Economic Forum reports that appeared last week, to show you where are the countries, but actually not only where are the countries, but the different levels. So calls to action are the green dots, roadmaps are the orange ones, and operational strategies are the blue ones. And you can see that actually operational strategies are still, very few. And when it comes to translating this into binding law, it's even less. So there's a lot of work to be done from a legal perspective here. So, having said all of this, I only have a few minutes to tell you about private international law footprint here. And Ralph has said already a lot in terms of the function, so I can count on your understanding of that. I think it's really important to conceptualize private international law as part of global governance, and in that sense essential if we want to transform and if you want to transform and transition to circularity. And the three functions that Ralph was talking about, coordination, facilitation, and regulation, are key towards that. And it is clear that this work ahead is ambitious and is on many fronts. So we have to start somewhere. So with Antonia Sommerfeld, who is the one taking the prize in the middle, I wasn't able to go to that prize ceremony. We started thinking about circular economy and legal design very much on the contractual side of things, because we thought, one way of thinking about this, as Ralph was saying, contract law is very much part of how the linear economy facilitates things. So how can we rethink contract law in a way that facilitates the transition to circular economy? So this paper, this specific paper that we did in 2024, was about a very niche part of the contract, which is a reverse retailing part. So when we're talking about recycling, reusing, it's not only important that that contract between consumers and that contract between businesses, we distinguish between business to business and consumer to consumer, and also business to consumer contracts. It's very important that there is an element there of possibilities to taking back the garment. So part of it is called reverse recycling or taking back systems, and are key systems to enable the circular economy. So a way of engaging with how the garment goes back to the retailer, so the retailer has a key role in facilitating circularity here. So that was a very initial point, and the paper won a prize, and we were very happy, but actually motivated us to go further with this. And based on this understanding that there is a lot to be done from a legal design and that private international law is key to that, we moved on to the project that I wanted to talk to you about. And I have 1 minute to tell you, and then 3 years ahead to work on it. So the project is called Fashion's Place, Private International Law and the Circular Economy, and very much looks at frameworks, legal frameworks, private international law frameworks to facilitate the circular economy in fashion. I do think there is a key issue here about awareness, but also agency in terms of production and consumption. I do think part of this is actually understanding how all of us as consumers do need to engage in circularity, but also engage to circularity in a meaningful way. And also understanding how uneven the picture of circularity looks at the moment. If you look at global trade, circularity in global trade at the moment, 90% of it is between developed or middle-income countries. Low-income countries have only 1% of that market, and the rest is, in that sense, when you look at the externalities of all of these problems are very much affecting those low-income countries. We have very little at the moment to gain from all of this. So I think part of what the project is looking at as well is that unevenness, and how we all, in a way, as I was saying, going back to SDG 12, is about responsible production and consumption, and I think reverses it to say consumption and production, how we have, in a way, a duty to look at this globally, and how international cooperation is very much pointed at, and again, in that World Economic Forum report that was published last week, how international cooperation is key to that. So many of the, and I'm finished in 2 seconds, many of the national policies of circular economy at the moment are very local. They don't necessarily engage with the scaling that is necessary to tackle this at a global level. The side of that, or the problem with that, is that a national policy of circular economy is very likely to generate negative externalities elsewhere. So the key thing is try to enable that globality of circularity, the interoperability of systems, and private international law, we think, has an enormous role to play there. Thank you very much for your attention.
Thank you very much for timely presentation, and also it's very thought-provoking presentation. So as we all connected, we are all responsible for excessive consumption, and private international law again has a role to coordinate and cooperate issues. I love the idea. Now, it's a great honor to introduce our third panelist, Professor Hans van Loon. Professor van Loon is the former Secretary General of the Hague Conference on Private International Law, where he served from 1996 to 2013, overseeing a period of significant expansion and institutional development. Professor van Loon had a distinguished career spanning legal practice, the judiciary, and international institutional leadership, and he is currently an honorary professor at the University of Edinburgh and a member of the Institute of International Law. Today he will speak on the role of judge in climate cases. Please join me in welcoming Professor van Loon. It's a great honor to have you. Please, floor is yours.
Teşekkür ederim Sayın Başkan. Herkese iyi günler. It's a real privilege for me to take part in this conference at the famous Bilkent University. And it's a wonderful initiative of our friend Gülüm Öçlik to organize this event on a theme, private international law and sustainable development, on which we have been working together, Gülüm and Veronica and Rolf and me, for several years now, and which led to our book mentioned by the Dean, The Private Side of Transforming Our World, and several conferences in different parts of the world. That book was inspired, of course, by the UN Agenda 2030 for Sustainable Development. And in that agenda, the heads of states of our world solemnly declared, we are determined to protect the planet from degradation, including by taking urgent action on climate change so that it, the planet, can support the needs of the present and future generations. Most of the challenges of the agenda are immediate, like poverty and health and education. And that's also true for climate change. But the additional challenge is that climate change has effects over hundreds, if not thousands of years, and so affects the future of our children, grandchildren, and many generations to come. This is an overview of what I hope we can discuss. Sustainable Development 13 specifically addresses the need to combat climate change. And I'd like to briefly address the global legal framework on climate change. Next, today's reality. And then turn to our theme, the role of the judge. While governments are lagging behind, as a result of strategic climate litigation, judges around the world and at very different levels have become amazingly active regarding climate change. And this has even led to concerns that judges are sidelining the legislative and executive powers. But last year's advisory opinion of the World Court, the International Court of Justice, on the climate obligations of states has shown how great the need for judicial guidance is. Now, since this conference is about private international law and sustainable development, I've selected 4 recent cases, 3 of them ongoing, to illustrate the role of cross-border climate litigation and judicial intervention. And then we'll conclude with a few takeaways. Agenda 2030 is not a legislative text. It provides no rules. It projects quantitative goals with sub-goals and indicators, and they are addressed to everyone. How they should be achieved is open through economic, political, legal means, but it is for sure that quantity is not enough, that we need qualitative changes of our behavior. So law, norm setting and norm enforcement is one of those. That also applies to SDG 13 on climate change. But as you see, this SDG is essentially formulated in terms of national government policies. Few people would have expected that the judiciary, that a judge, would become so involved. The principal global legal framework for climate action consists, of course, of climate and environmental treaties, the UN Framework Convention on Climate Change, the Rio Convention, then the Kyoto Protocol, then the Paris Agreement of 2015, adopted just after the adoption of Agenda 2030. And there are specific conventions, such as on biodiversity. But apart from these climate and environmental conventions, rather surprisingly, a second pillar of the framework has recently emerged, namely human rights instruments, both at the global and the regional level. And then the ICJ, in its advisory opinion, also clarified the role of customary law. But then, where do we stand with the implementation of all these beautiful norms? Not so good, as you know. And importantly, we have objective evidence for that, thanks to the World Meteorological Organization and the reports of the International Panel on Climate Change. The problem is, as you know, that the incoming energy of the sun is not compensated by outgoing energy from the earth. The oceans do their best enormously, land does its best, ice caps do their best, even the atmosphere does its best, but the fact is that warmth stays within the atmosphere, that the earth is warming up, that not enough energy is going out. So we see, in fact, that it is one negative record after another. Current policies now predict 2.5 to 2.9 Celsius warming up by 2100. The short story is that the gap between climate rhetoric and climate action in all forms remains the defining governance failure of our era, with lots of other problems, but this is a very crucial point, of course. And this is where, surprisingly, judicial intervention comes in to address this governance gap. And it's courts at all levels, national, regional, global. Individuals and NGOs have propelled thousands of cases in over 50 countries. I think it's now 55 or so, including Turkey. And these cases are based on constitutional law, on administrative law, on civil and commercial law, including private international law. And they claim damages, or they claim injunctions, or both, as we shall see. And we are witnessing a very fascinating cross-fertilization in a sort of dialectical movement, vertically bottom up and down, national, regional, and global levels, and horizontally as well. And this has been a very recent development. First, we saw judges sort of declining to intervene, asking questions about their role, both in cases against governments and in cases against companies. But we saw also a very rapid development. Here are a few examples of litigation. First against governments. In 2020, the federal Court of Canada refused to hear a climate case. Then we have the American court in the Juliana case. It's a very interesting case, but you see the struggle of the judges. Two judges said, well, it is terrible what is going to happen, but we don't have the power to intervene. What did the third judge say? We have to. So there's this strong dissent, which is interesting to read. And then again, this refusal by the Irish Supreme Court that says we should not listen, we should not blur anything. You have the judge, you have the legislature, you have the administrative side, and we should not cross the borders. And then in the meantime, the Hague District Court, in the summer of 2015, in the running up to the negotiations on the Paris Agreement, took a revolutionary step. And on a claim in the public interest by the Dutch NGO Agenda, ordered the Dutch government to do more to reduce CO2 emissions by 2020. And to everyone's surprise, the Court of Appeal and even the Supreme Court of the Netherlands followed suit. Moreover, the Supreme Court based itself on the European Convention on Human Rights, despite the fact that this convention explicitly says that actions in the public interest are not for the convention. And that in turn paved the way for the recent case before the European Court of Human Rights, the Klimasignorinen case against Switzerland, where in 2024 the court allowed the NGO to bring the case before it, but denied, paradoxically, the case of the individual plaintiffs, the elderly ladies. In a New Zealand case, also in 24, 2 years ago, the New Zealand Supreme Court created an opening where a few years before it, 1 or 2 years before it, the Court of Appeal, in a very recent opinion, had said, no question, we cannot deal with this. This is for the legislature. And it will be very interesting to see what the Turkish Constitutional Court will say about the role of the judge in relation to nationally determined contributions to the Paris Agreement. Every 5 years, governments have to submit a plan, and the question here is that something that the judge can talk about, can order about, or not? I found in my research about 10 cases in Turkey about climate change. There may be more. I found it very interesting and encouraging. The question of judicial activism also arose in climate cases against companies. And already in 2020, the Philippine Commission of Human Rights made a strong statement on that respect. And then the Hague Court of Appeal in Milieu Defensie versus Shell, a case that we will come across later on also, pointed out that the sole question is whether the company has a legal obligation or not. And it does have such an obligation, at least under Dutch tort law, which, under the social standard of care, which the courts have interpreted in the light of the European Convention on Human Rights and soft law like the UN Principles on Business and Human Rights. All these cases at the national and regional level have percolated, so to speak, upwards to last summer advisory opinion of the International Court of Justice on climate change obligations of states. This is a remarkable, very clear piece of work. And if you haven't read it, I would strongly recommend that you do. It is a very interesting document. It's again the result of a strategic legal action, first by students and then by island states in the Pacific. We can't go into that, just a few highlights. As national and regional courts had done, despite objections by defendants, the ICJ bases itself very clearly on scientific evidence, notably the reports by the IPCC, the International Panel on Climate Change. It's clarified the climate change. You know, in the Paris Treaty, it says we should stay below 2 degrees, and if it is possible below 1.5. The court reverses it and says, no, 1.5 Celsius is the maximum. Remarkable. It declared customary diligence obligations. There was a first, an earlier ruling on transboundary and environmental harm, and the court said that is also applicable to climate change. And then they spoke explicitly about fuel production, consumption, exploration licenses, and subsidies. Now, as national and regional courts had done, and continue to do, the ICJ declared that protection against climate harm is a matter of human rights as well. And so states must regulate the activities of, including private actors such as companies. And arguments such as, yeah, my state is but a drop in the ocean, what we do, or my share cannot be determined, or climate change is not just caused by me, so why should I be made liable? They were rejected by the court, very helpfully, again relying on advances in climate change, like the science of climate attribution to either states or companies. And on top of that, these obligations are ergo omnes, so every country can bring a case against any other country causing climate change. The opinion has already had an effect on ongoing judgments before national courts, but we can't go on into that. Let's turn now to cases with specific private international law aspect. We already came across the case of Milieudefensie versus Shell. Here we see the members of the NGO waving in front of the District Court of The Hague. The claim of the NGO was that Shell should reduce its greenhouse gas emissions by 2030 by 45% in comparison to 2019. Shell's first defense, as expected, was this is not a matter for the courts. This is for the legislator. As we already saw, the court did not buy that. The jurisdiction of the Hague Court was not a problem. Article 4 of the Brussels I regulation importantly establishes a firm basis at the place of the company's domicile. Now, in this case, Shell moved its seat from the Netherlands to London, but that was not a problem. The jurisdiction continues. That's also clear. There's no discussion about that. The Dutch law is exceptionally lenient regarding the legal standing of NGOs, so much so that the NGO sort of absorbs individual claims. They are no longer admitted. And so if there are foreigners in different countries, which might give rise to a PIL problem, private international problem, that disappears because it is the Dutch NGO which is sole considered to be the party. Regarding choice of law, Milieudefensie argued that Dutch law applied because that was the law of the place of the event giving rise to the damage, Shell causing the damage. Shell said, no, that's not true. What we decide at our headquarters is just a preparatory act. We are not producing damage. It's the individual subsidiaries all over the place that cause, perhaps, the damage. So that would lead to a myriad of applicable laws, and that was not what the court thought was a good idea, so that argument was rejected. And Shell, in appeal, did not repeat it. So they also may have thought, well, we complicate the case enormously if we maintain that defense. The Court of Appeal overturned the district court's decision. They agreed with the district court that companies do have an obligation to contribute to the mitigation of dangerous climate change, but they did not buy the argument of the district court that Shell had an obligation to reduce its emissions by 45%. They said there is no such a fixed obligation in terms of percentages. Companies are free in their approach as long as they maintain their eyes, they keep their eye on the ultimate goals of the Paris Agreement. But the court also made an interesting remark. They said, well, Shell, be careful with drilling new oil for new oil and gas fields. And the NGO noted that carefully, and so they launched not only an appeal to the Supreme Court, and that is ongoing, but they also started fresh proceedings specifically on new investments by Shell. We'll see how that goes. The Shell case was about reduction obligations in general. By contrast, the case of the Peruvian mountain guide Luciano Llulla against the Germany energy giant RWE in Germany concerned the concrete damage that Llulla claimed as a result of the flooding of the glacier lake behind his village. You see there's the mountains, the Andes Mountains, the lake, and here is the village. And you see that he already made pipes to get rid of the water. And he said that will continue, this rising water level. And it all comes because RWE, over the years, has been responsible for 0.5% of the CO2 emissions on the planet. And so I want to have my costs covered. The district court in Essen was not impressed. It did not question the issue of jurisdiction. There was again clear that it was the domicile of the company, no problem. But the district court said, come on, there cannot be a causal relationship between emissions in Germany and the glacier melting 10,000 kilometers. Come on. The Court of Appeal disagreed. It declared the case admissible and ordered the taking of evidence in Peru. That took some years due to COVID. But then in May of last year, the Court of Appeal gave its final decision. And although they dismissed the case, there are very interesting considerations in the judgment. Choice of law was not an issue because the two parties, in accordance with Article 14, paragraph 1 of the Rome II regulation, agreed on German law. But then they said, and that was more a question of interpretation, I think, of German substantive law, as a matter of principle, major greenhouse gas emitters, not everyone, major greenhouse gas emitters, we are all greenhouse gas emitters, can be held accountable for the impacts of their emissions under German civil law. And the fact that RWE had a public permit for its emissions, that's not decisive, because it doesn't justify interference with property rights, no matter whether the place of emission and of damage are, as in this case, 10,000 kilometers away from each other. However, the appeal failed because the evidence showed that there was only a 1% probability that the lake's flood would, in the foreseeable future, reach Llulla's home. This case builds on Llulla's case. However, this is here the alleged damage. You can almost see it is visible, almost tangible, urgent and immediate, like in the case of the Pacific Islands in the ICJ opinion. Pari Island is an island north of Jakarta, just above sea level, and what is going on, of course, sea level is rising, and people are afraid of their livelihood of their existence. So Mrs. Asmania and 3 fellow islanders claim that the Swiss cement giant Holcim, based in Zug in Switzerland, is partly responsible for their troubles. And they claim damages, an order requiring Holcim to reduce its emissions and help with adaptation measures. Now, regarding the jurisdiction of the Zug court, where Holcim has its seat, again, there's no problem. Private international law is in a good shape there, because Lugano has the same rule as the Brussels Convention. There is a firm domicile. Okay, regarding the admissibility of the claim, Holcim presented the usual argument that this is a public law, this is a private, public law in disguise, is not a private matter. The court declared the case admissible. They didn't accept that argument. The plaintiffs, they said, have a clear, concrete interest under Swiss civil law. Their rights, their private rights are directly at stake, and Holcim also determines the policy everywhere on the planet, so yes, they have a point when they sue Holcim. The court relied, by the way, on the Hague Court of Appeal's decision in the Shell case. The case is now before the Superior Court in Zug, and we have to wait for the next decision. I'm almost there, Madam Chairman, if you allow me a few minutes. And this is a brand new case. The judgment by the Belgian court in Tournai, south of Belgium, came off last month in March. It's about the Belgian farmer Hugues Vallis, who you see here in the front, who has suffered heavily from rain, showers and droughts, for which he says the energy giant, the big oil company Total is partly responsible. And he wants compensation for his losses. He wants an order to stop Total from investing in new fossil and oil drillings. He has carefully studied the Hague Court of Appeals case, Shell case, and he wants an order for Total to reduce its emissions. Now, regarding the Belgian court's jurisdiction, the defendant, Total, says greenhouse emissions are diffuse, so there is no single cause of damage, and therefore there's no reason to depart from the main rule of the Brussels regulation, namely the domicile of the company, which is, of course, in Paris. The Belgian court had little difficulty with this argument and referred to the well-known case of Mine de Potas, 1976. As a junior lawyer, I was involved in that case. I'm afraid on the bad side, but that is another matter. The plaintiff may choose between the court of the place of the damage and the court of the place of the event causing the damage, and in this case it was the place of the damage because that was in Belgium. The issue of admissibility was also quickly resolved. Vallis had a direct personal interest under civil law, no problem. However, the court had to stay the case based on Article 30, paragraph 1 of the Brussels regulation. Why? Because there was another case against Total relating to its drillings in Tanzania and Uganda going on, and that decision would follow this summer. So the court in Tournai said, let's wait for that and then we will continue the case. This Belgian case builds on a case a little comparable to the Urgenda case in the Netherlands. There was also an earlier case against the Belgian government. But it's remarkable to see how straightforward the court's reasoning is. It's a relatively short judgment, and how they arrive with little difficulty at their conclusions, which show comprehension, understanding for the victim. I must conclude. We have seen that literally all around the world, climate lawsuits are springing up. They create a new playing field, a new narrative in legal terms. And the cross-fertilization of these cases, upwards and downwards and horizontally, is truly remarkable. The initial argument that climate matters are too big for the courts, belong to the political arena, it seems does no longer impress the courts. For the courts, what matters is there a legal basis for the claim in constitutional law terms, in administrative law terms, in civil and commercial law terms. And at the admissibility stage, the usual arguments, I'm not the only emitter, others contribute too, if I stop, others will take my place, etc. They are no longer easily accepted by the courts. Private international law issues, in a narrow sense, are not a serious obstacle, it seems, because there we have our house relatively well in order. And then we have the Rome II provision on applicable law, which is also very useful and has been invoked by the parties. And once the applicable law has been relatively easily determined, the courts find ways to interpret civil substantive tort law in the light of human rights treaties and soft law instruments such as UNGP. And it is quite remarkable to see how courts embrace legal science in their courts. It's really a very important basis for their judgments. To me, what is so heartening is that so many judges around the world have shared the vision that there is a role for law where governments and companies are lagging behind. And I think that's an encouragement to all of us to keep up the good work. Thank you very much for your attention.
Thank you, Professor Van Loon, for this very extensive court cases. And I didn't know many of them, so it was totally new, some of the cases for me, and I think for most of you. And I like the conclusion part because there is still hope to stop this climate changes activities. Now it's my pleasure to introduce our fourth panelist, Associate Professor Dr. Gülüm Özçelik. Dr. Özçelik is a faculty member in the Department of Private International Law at Bilkent University Faculty of Law. She completed her undergraduate studies at Ankara University Faculty of Law. She holds an MA in International Relations from Middle East Technical University. She holds also an LLM in European Law from University of Exeter in UK and a PhD in Private International Law from Ankara University. She has been teaching at the Faculty of Law at Bilkent University since 2009. Her research and publications focus on private international law, international arbitration, European Union law, and migration law. Since 2024, she has held the Jean Monnet Chair in Legal Aspects of Migration Management in the EU and Turkey. Today, she will present on recognition and personal status acquired abroad. Floor is yours.
Thank you very much, Professor Tiryakioğlu. Dear Professor Başak Baysal, Dean of the Faculty of Law, dear esteemed colleagues, students, and dear participants. I am very honored to be here today sharing the same panel with Professor Ralph Michaels, Professor Veronica Ruiz-Abonim, and Professor Hans van Loon. I am thankful to them for accepting my invitation to organize the first Private International Law and Sustainable Development Conference in my country. I am personally very happy to have them here because, as Hans has mentioned, we've been through different projects together in different beautiful cities of the world, but for the first time at home for me at Bilkent University. I also extend my best wishes and sincere thanks to Professor Başak Baysal, without whom I could never do it by myself. She has given the invaluable support from the moment she heard that I've manifested something like this doing at Bilkent. So I am very thankful to her and her excellent team at the faculty secretariat. My presentation today is about the recognition of personal status acquired abroad, not a new subject in private international law, however, has become more important in the last decade because mostly because of the mass migration flows we've witnessed in most parts of the world. I'll try to relate the topic with three SDGs, targets in certain SDGs, three SDGs, 5, 10, 16, as much as possible within the time left for me. So first, starting with what we mean with personal status and why does recognition matter. Personal status, in very short, is defined by as individual's position in a legal system. It is usually defined by law of persons and family law. Issues such as legal personality, capacity, name, parentage, adoption, marital status, establishment of marriage, different types of marriages, or dissolution of marriage comes within its scope. Normally in legal systems, the legal status, personal status, is either established by acts of official authorities in civil registries or judgments. Therefore, both situations bring issues of private international law, recognition of legal acts and recognition of judgments, and the solution of private international law or the techniques that could be applied is differently depending on recognition of which document we are speaking about. But today I will try to focus on two issues, the last two issues you see on the slide: recognition of civil status documents and recognition of the validity of personal status, which is required abroad. These two questions are related with the main objective of private international law, to provide cross-border continuity of personal status and to avoid limping relations, that is to say, a relationship which is valid in one country and invalid in the other. So, as I said, we can have relevance with three SDGs or certain targets of three SDGs. The first one was also the chapter I authored in the book. Previous speakers has mentioned the private side of our world, or the sustainable developments and private international law. That was SDG 5, gender equality, achieving gender equality and empower all women and girls. Here, as regards the topic of the presentation, I think target 5.1 is the first relevant one, which is widely regarded as foundational to the broader gender equality agenda and to the achievement of sustainable development as a whole. So it provides ending all forms of discrimination against all women and girls elsewhere. The second target is 5.3, which emphasizes the urgent need to eradicate the harmful traditional practices that undermine the dignity, health, and rights of women and girls, recognizing that their elimination is fundamental to achieving equality and sustainable development. Third, or the second SDG, but the third target, would be under SDG 10, reduced inequalities, the target number 7, which aims to facilitate orderly, safe, regular, and responsible migration and mobility of people, including through the implementation of planned and well-managed migration policies. It addresses the governance of international migration, emphasizing the human mobility should occur through regulated, predictable, and rights-based frameworks. Therefore, it distinguishes between orderly and regular migration, meaning the movement of persons through legal and recognized channels, safe migration, protection from exploitation, trafficking, and dangerous travel conditions, and responsible migration, the policies that balance the interests of migrants, the countries of origin and destination. The last SDG that I find it very important, that was that part was written by two esteemed colleagues, Sabine Kanup and Jinske Verhellen, in our book, that is SDG 16, Peace, Justice, and Strong Institutions, and its target 9, which emphasizes that legal identity is a foundational enabler of rights, inclusion, and effective governance. By ensuring that every individual is officially recognized, starting with the birth registration, it supports equitable access to services, legal protection, and full participation in society. So if we move to my first question, my first issue on the recognition of civil status documents, personal status has important consequences, not only in private law, including family law or law of persons, of course, but also on law of nationality, migration law, and tax law. Therefore, in most countries, the elements of personal status are registered in civil status documents, including birth, marriage, and death certificates, and they serve as proof of legal identity. A civil status document issued in one country under the traditional rules of private international law must be legalized in another country, and this is subject to the rules of civil procedure or international civil procedure of the country where recognition is sought. Legalization is a very long process, so one of the most important international documents aiming to abolish the legalization requirements is the 1961 Apostille Convention of the Hague Conference, and there are other Hague conventions that have the same aim of simplifying legalization and facilitating recognition of personal status. Other than the Hague instruments, there is the European Convention on Abolition of Legalization. There is the EU regulation simplifying the requirements for presenting certain public documents between the member states. So the international conventions are at place to an important extent. But there are important challenges in today's world. First, to speak about legalization or apostille, we have to have a document, an official document. In today's world, due to national disasters, conflicts, migration, or administrative oversights, there might be situations that there is no document at all, or the document cannot be legalized, or the document is found fraudulent or false, therefore it is unreliable. So these are the challenges challenges that wait for answers from private international law or from any other area of law, such as migration law, because these issues are particularly important for migrants. This is not only issues of private international law for them. Birth registration prevents statelessness. Proof of age protects the unaccompanied minors. Proof of marriage and parentage are required for family reunification and residence permits. So academia and some countries and some courts try to find what are the alternatives. If we are looking for alternatives of authentic instruments, what could this be? Taking the sustainable development goals, taking the rights of the woman, the best interests of the child into consideration, especially in cases where there are migrants. In most countries today, there are different solutions that are adopted or that are proposed. First might be, and this is applied in some countries, is supplementary judgments, where these normally are in form of declaratory judgments. When birth certificates are missing, for example, there is a possibility to recourse to a national court to make a judgment on the birth of that person. Or in some countries, age assessment procedures are used, such as medical examinations or interviews or bone tests. Some court decisions exist, for instance, and some examples exist from Belgian law, that they accept non-authentic documents for some situations to guarantee the best interests of the child, such as identity cards or passports or certain embassy documents might be found adequate to determine the age of the child. Or genetic tests to prove paternity, maternity, or maternity DNA tests used to prove parenthood. Proof of marriage, of course, doesn't have a test itself, but interviews are used as a tool, as an alternative tool to prove the marriage between the spouses, or genetic testing confirming shared parenthood is also possible in some countries. So this question, as particularly for the vulnerable people, is required. There is also place for further international cooperation on civil status, although the International Commission of Civil Status has adopted several conventions to assist migrants and facilitate cooperation, that facilitates cooperation. Because of the low number of contracting countries to these conventions, the aim is not unfortunately achieved. So what could be recommended for this part of this problem is that a more holistic approach should be adopted. This is not only a question of private international law. Private international law techniques might not be sufficient to overcome this part of this problem. So what we need is to overcome this traditional but outdated divide between private law and private law and public law, and to think about better ways of collaboration of private international law and migration law. Cooperation is also required between public and private authorities, also between countries of origin and destination. What could also be suggested after Hans van Loon, because it was his suggestion, is to stimulate International Commission on Civil Status work and explore cooperation, further cooperation with the Hague Conference on Private International Law. So this was the first part of my presentation, the recognition of the civil status documents, which is an indispensable part of the personal status. The second part that has been discussed in Turkey very often in the last decade, and in some other European countries as well, that is a recognition of validity of personal status. This is not the document itself, but it is the status that must be recognized in other countries. I've given 3 illustrative examples on this slide. I'm inspired by 3 different courts here. The first one is the European Court of Justice, the European Court of Human Rights decision about a surrogacy agreement. A child was born via surrogacy in country B with a birth certificate naming the intended parents, but its registration was refused in the country of nationality of the spouses and the child because of public policy grounds. The second example is a recent decision of the European Court of Justice, the Court of Justice of the EU, about a same-sex marriage which was validly celebrated in one member state, however was refused, its transcription was refused in another member state because of public policy grounds again. And the third example is from Turkish Court of Cassation, where the court declared that a polygynous marriage between Syrian spouses was null and void because mainly it is against polygamous marriages are against Turkish public policy. So about the techniques of recognition of the validity of the personal status, we see that no unified method exists in the world. Depending on the courts, depending on the academics themselves, there are different implementations, there are different suggestions as well. In the EU, for instance, in the judgments of the Court of Justice, we see that the court grounds recognition in the principle of mutual recognition, the freedom of movement, and European citizenship, which could only be valid, of course, between the member states of the European Union. In some countries, there are express rules on recognition. The International Convention, the Hague Convention, has of 1978 on the recognition of marriages, has one example of recognition provision, and another one exists in Swiss Act on Private International Law, which provides that a marriage validly concluded abroad shall be recognized in Switzerland. In other countries, including Turkey, and today I learned that it is Germany as well, provided under the German Private International Law Act, we don't have any recognition provision. But what we could do in such cases is, like in most other countries, we use the choice of law provision that is provided for the establishment of that relationship, say a marriage, also as a rule to recognize the marriage, for instance, that is established abroad. Therefore, in such cases, the conflict of law rules, the choice of law rules has two functions, both to establish the relationship and second, to recognize the relationship. However, having said that, the application of the same rule doesn't have to be the same depending on the situations. Let me give two examples, one from polygynous marriages, the second one about child marriages, which have been very much discussed here. Polygynous marriages refers to marriages where one man can marry with 4 women, and it is accepted in Islamic law in several West African countries, either in law or in practice or by tradition. In other countries, including Turkey, polygamy is not accepted, but it is prohibited by law. So imagine 2 Syrian nationals who would like to celebrate a marriage in Turkey, or where when they want to get married, celebrate a marriage in Turkey. That would be subject to Article 13, Paragraph 1 of the Turkish Act on Private International Law to find out the substantive requirements of their marriages. This provision refers us to the law of nationality of each spouse. That means Syrian law would apply. Although under Syrian law, that is a possible marriage, the Turkish public policy, as provided under Article 5 of the Act, would possibly intervene here and will say, no, even if it is possible in your legal systems, it is not possible here, because that would undermine the Turkish public policy, since Turkey is one of the countries that has established monogamy. This provision, although could be perfectly applied in the recognition of marriages, I think, and most scholars in the area, I think, share this view, that the public policy exception here must have an attenuated effect, meaning that public policy should intervene in even more limited situations. We have to consider the rights of the woman in such marriages as well. If we just say the marriage is against Turkish public policy, for instance, we would equally undermine maintenance and succession rights, pension and social security benefits and legitimacy of children which were born from that relationship. So we, to consider the rights of the woman as provided under SDG 5, public policy exceptions should even be applied more exceptionally when it comes to the recognition of polygamous or polygynous marriages. Of course, one important issue here would be proximity, meaning that if this marriage has got very close ties with Turkey, then of course it would be possible that Turkish public policy would intervene. However, if this marriage was celebrated in Syria some 30 years ago, where the people would not even aware of the fact that they would have to migrate Turkey because of the internal conflicts in Syria, then that would be, I think, a wiser idea to consider certain rights of the woman as well. The same applies for the child, recognition of child marriages. If we reject categorically that the child marriages which were celebrated in another country validly under the law of that country, then we could also undermine realities of migrant women in some situations. That attitude would ignore the fact that some migrant girls marry to protect themselves from sexual violence during the migration routes or in refugee camps. This would also undermine the possibility that they should have certain rights arising from divorce, from maintenance, from succession, and matrimonial property. This would also empower the husband, because then he would have the possibility to remarry and claim nationality or residence rights. So a case-by-case analysis is required when it comes to recognition of polygynous marriages and child marriages. I think this concludes my presentation. Thank you very much.